I had my marriage-based AOS September 11th. The case was on review. On the 4th of October, 3 weeks after the interview, I checked my status. My I-175 employment authorization updated to new card was ordered. My question is, why is my EAD coming after the interview? And when the interview is still on review, should I be worried about about the reviewing case, or what should I expect from USCIS?
Well, you can expect one of three things on review. One, your case is approved. Two, your case is denied. Or three, no response whatsoever. And if a no response whatsoever, they have actually 120 days. Actually, there's four choices. There's your case is approved, your case is denied, you're going to get a Stokes interview, or you get no response. Hopefully you get either a second interview, or more likely, or hopefully an approval. If you get a denial, then you obviously got to deal with it. You also have to deal with a no response. A no response is they just leave your case pending forever. And that, to me, a no response is like a denial, because a visa delayed is a visa denied. So you got to deal with those different options depending on how they come in. So you got to see what's going to happen. In the meantime, be happy you're getting your work permit, so at least you can work legally, get your social, and hopefully it's a combo card and you're able to travel too.
Our next question comes from One Block, who said, "This is a great show." Well, that's not a question, but thanks, One Block. If I filed an I-751 and I divorced after filing, should I tell USCIS or just wait when I get my 10-year?
No, tell them, because if you get your 10-year and you are divorced and they think that you are married, then you're committing a fraud and you're going to have a problem with your citizenship. So once you are divorced, or once you even start the process of divorcing, you got to write immigration. You got to tell them you're in the process of getting divorced, you are divorced, and convert the case to a waiver based on a bona fide marriage that terminated.
My joint sponsor last year had made enough money to sponsor me, but since December 2018, she's not working because of her school. Can she still sponsor me?
Yes, but if she's not working for the last year and a half, she doesn't sound like a very good joint sponsor. I would look for somebody else.
Tanny said, "I just got my green card and was wondering if it's safe for mom to go to the embassy and try for her visa, or if there's going to be an issue."
No, let her try.
Can the joint sponsor be the one that makes the $60,000 or the main sponsor? And also, would you expedite removal come up on an FBI fingerprint search?
It would come up on an expedited removal would come up on a fingerprint search, because you got fingerprinted if you had an expedited removal. Somebody's got to make money. So whether it's the main person or the joint sponsor, we don't care, but somebody's got to be making the money.
Miles 7's got a question from a friend. "I've got 4 children with my previous wife, but we've gotten divorced now, and I'm now living with my current wife in New York, and she's got 1 child. But my ex-wife is now living in New Jersey with the children, and I'm doing everything for the children in terms of their needs. Should I be worried because myself and my U.S. citizen spouse are going to be attending the green card interview on Thursday?"
What seems to be the problem?
So it sounds like his ex-wife has custody of the children, but he pays child support, I want to say, because it says, "My divorced wife, my ex-wife is living in New Jersey with the children, and I'm doing everything for the children in terms of their needs."
Yeah.
So it sounds like he just doesn't have custody of his children, and it sounds like he's wondering whether that's going to be an issue.
No.
All right, next one, Natasha is saying, "I got a Prima Facie determination." What does this mean?
It means that immigration looked at your VAWA case, and based on just looking at it, seems like everything's in order, but they got to take a closer look to get the approval.
Alti Morris said, "My friend needs to have her mom co-sign the affidavit of support. However, her mom died. What steps can she take to complete the process?" And she's already paid the processing fees, and so the next step was just to go to interview. So what does she do now?
What do you mean co-sign an affidavit of support if your mom's the petitioner? If your mom's the petitioner, you got to substitute a new petitioner in. If your mom had nothing to do with this petition, then you need to find another co-sponsor.
Okay.
All right, Felix Michelle is saying, "What if my husband is not making enough to sponsor me on the I-864 and a family member is willing to sponsor me? Is my husband still required to complete and submit an I-864 showing his income?"
Yes. Yes.
Jay Barth said, "My brother overstayed his visa and is in an ICE detention center for domestic violence with his wife. Could he escape having to be deported by fighting his case?"
If his wife wants to help him and they make up, yes. But if not, he's going to get deported.
Ankar is saying, my brother's I-130 is approved on 2014 March. Now he has a fiancé here in the USA and she wants to apply for a fiancé visa. Is there any problem applying for a fiancé visa while the I-130 approved is pending?
No, you can have multiple ways to get a green card, whichever comes in first.
Sheena said, in my previous marriage, my husband had started the process to file for me for a green card, but the marriage was not working out. So I filed for divorce and I did not follow up with the paperwork. Now I'm planning to remarry and my future husband would like to adjust my status for me. How do I approach the previous case and would it require a lawyer? And if so, how can I hire you?
Well, you can call 1-800-529-5465, and as a lawyer, I always say you need a lawyer. But that's a lawyer saying you need a lawyer. But how do you approach the prior case? You had a prior filing, it didn't work out. And now you're filing again. You're allowed to file multiple times to try to get a green card as long as there's no fraud involved.
Can my stepmother sponsor me to come to the U.S. because my father died? And if so, what must she do?
If your stepmother married your father before you were 18, she can sponsor you, and you just have to show that you have an independent relationship with your stepmom.
Should my husband get a job letter to submit with affidavit for me? He's currently working out of the country.
Yes.
Nabil said, I recently became a U.S. citizen and I want to sponsor my spouse when I get married, but I'm enrolled under Medicaid. Is that going to affect the sponsorship?
Yes.
Missy Jam saying, I submitted my adjustment of status via marriage, but I didn't submit a medical. And with all these changes, I'm scared USCIS might not send out the request for it. Should I just go ahead and submit it now?
No, do not submit it unless you get a request. And if you don't get a request, bring it to the interview.
Our next question comes from Aman, who said, I married a U.S. citizen under 30 days on an ESTA visa. I already overstayed, and my lawyer told me not to file the adjustment because in the interview, they're going to deport me because of the 90-day rule. Is that true? And if so, what's your solution?
She got married when?
On an ESTA and under 30 days.
You need a waiver. So your choice is this. You could live illegally in America forever, or you can file an adjustment and a waiver and do the best you can. Those are your choices.
Why would the lawyer just say don't file anything?
That doesn't make any sense.
That's such an odd lawyer.
That's like running away from your problem. Then
if I don't see it, they won't see it.
Yeah, don't worry about it. Just go.
Yeah, I mean,
you already broke the law. Don't worry about it anymore.
Just live here illegally forever.
Right.
No, thank you for the question, Aman. That was terrible advice at first.
All right, I have a tweet saying, asking for a friend. He submitted an I-130 for his wife last week, and he would like to know if the new rule on October 15th will affect him.
Yes.
Kiski Taylor said, can I use a social security number? I got on a J1 program to file taxes with my U.S. spouse in January, and we have not submitted the paperwork as of yet. My husband got an impromptu deployment right after our marriage until February 2020.
Well, send the paperwork to your husband wherever he is in his impromptu deployment and put in the paperwork for the adjustment so you can get a work permit and your social. And if you get an interview before he comes back from his impromptu deployment, then just show that he's impromptu deployed somewhere, and they'll reschedule for when he comes back.
All right, and our last question for right now comes from Jad saying, I have a question. I applied for a VAWA in October 15, 2018 and still in process. Can I apply for a Matter of Sesay? And at the same time, I entered the U.S. with a K1.
You do Matter of Sesay if you're not with your spouse anymore. So is he with your spouse?
Does not say.
Okay, so Matter of Sesay has to do with you're not with your spouse. It doesn't have to do with the length of time your adjustment is. Thanks for watching. For more Brad Show Live, like and subscribe to our YouTube channel.